Good afternoon, Your Honor. Angela Chin here.
Yep. All right, thank you.
Right from the opening seconds, this case sounds like a routine eviction dispute. Landlord versus tenant. But as you're about to see, what begins as a simple termination case quickly unravels into something far more complicated. We're not just talking about unpaid rent here. We're talking about allegations of unsafe housing conditions, a fire-damaged property, a possible illegal rooming house, and even accusations that the landlord's father changed the locks and removed a tenant's belongings. That's a serious allegation because under most housing laws, landlords cannot simply change locks or remove tenants without going through the legal eviction process. Doing so could qualify as what's known as a self-help eviction, which courts take very seriously. And listen closely to the judge here, Judge Simpson, who immediately starts asking pointed questions. Experienced judges often cut straight to the heart of a case within minutes, and you can already hear the skepticism forming in his tone. Is this a landlord trying to evict someone who stopped paying rent? Or is this a deeper issue involving property compliance and tenant rights? Because if the property isn't legally registered to be rented, and that becomes a major issue later, the entire case could flip upside down. So as this hearing unfolds, keep one key question in mind. Who is actually in the wrong here? The landlord, the tenant, or both? This case is about to get a lot more complicated than anyone expected.
Your name, ma'am?
Janelle Smith.
All right. And where are we on this? This is a termination case.
Correct, Your Honor.
And the basis for the termination is,
Basis of the termination is lease agreement has ended, and also, there's the tenant has been having problems being able to pay for rent, and she has like 2 years worth of rent payment and utilities that has accrued.
so is the lease ended?
I never had a lease with her, and the whole thing was back in September. I had a fire at the house. The fire department came out, and the city ended up saying that the house was uninhabitable, because the toilet fell through. Angela let me stay there for free, but what happened was when the fire department came out and they saw that the toilet was falling through and that the fire was in the wall, her father, which we were on the call last week, got upset about it, and the city came out and said that the house I couldn't live there. So that's what the situation is with this.
And may I add on to this? We've tried to
Sure.
work with Janelle to try and find a time for maintenance. And we've done a lot of maintenance, and we're actually actively working with the city.
This is a classic argument we see in landlord-tenant disputes. The landlord claims they tried to make repairs, but the tenant refused to cooperate or provide access to the property. From a legal standpoint, this detail actually matters a lot. Most jurisdictions require tenants to provide reasonable access for repairs if the landlord gives proper notice, usually 24 hours. So if the landlord can truly prove that they repeatedly attempted to schedule repairs and the tenant ignored those requests, that could strengthen the landlord's position in court. But there's another side to this story that complicates things. Janelle is claiming the property was declared uninhabitable after a fire and structural damage, including a toilet literally falling through the floor. If that's true, then the responsibility shifts heavily onto the landlord. Housing laws require landlords to maintain what's called habitability standards, meaning the property must be safe and livable. If the home was unsafe, tenants may have legal grounds to withhold rent or demand repairs. So now the big question becomes, was the landlord truly trying to fix the property? Or were the conditions already so bad that the tenant had a legitimate reason to push back? And Judge Simpson seems determined to get to the bottom of it.
But however, because she hasn't been very cooperative, she hasn't really responded to my text on, like, I asked her, like, what is her availability? Can I provide contractors to come in? She never really replied back to me, and I have text messages and screenshots to show that case.
First thing is I guess my first question is the house registered with the city to rent?
So
It-
I gave
Hold on. Yes, ma'am. Ms. Chen?
Yes, we are actively working with the city, and we got approval with the city last year. And everything was, or last year or 2 years ago.
Does it have a current valid certificate of
Not
compliance?
currently, not currently. We're working
Got
with
it.
the city to, but because of the repairs that Janelle mentioned, that we need to fix the subflooring on the toilet, that was one of the biggest issue. But because we can't have access to the premise, and my father has been a lot of
I
the
don't know who can't, I mean, there are ways of getting access to the premises, even if he disagrees to get access. So I'm not sure
That was not what happened. He came in, he changed the locks. The
who
city,
changed a lot.
her father, the city came out. I,
When?
this happened in December. I submitted all the paperwork from the city and everything, how he came out.
Yeah, that's fine, but
Came out
he came,
and he removed my things
he was?
and he removed my belongings.
May
And
I
the guy,
interject, Your Honor? During that time, this is an emergency situation. We had to have, the boiler is out and we had to have, there was no heat in the house. And this is back in November.
Now we're entering one of the most serious accusations in the entire case, the alleged lock change incident. Changing a tenant's locks without a court order is extremely risky for a landlord. In many jurisdictions, it's outright illegal. Courts refer to this as a self-help eviction, meaning the landlord attempts to remove a tenant without going through the legal eviction process. And according to Janelle's testimony, the landlord's father not only changed the locks, but also removed her belongings from the house. If that allegation is proven true, it could expose the landlord to significant legal consequences. In some states, tenants can actually sue landlords for damages when illegal lockouts occur. Judge Simpson immediately zeroes in on this issue. Notice how he keeps asking a simple question: did he change the locks? That's not accidental. Judges often repeat direct questions when they suspect someone may be trying to avoid giving a clear answer. And when the landlord finally confirms the locks were changed, even partially, you can almost feel the tension rising in the courtroom. Because if the court determines that a lockout occurred while the tenant still had legal possession of the property, that could dramatically change how this case proceeds.
And I could give you the specific dates. I've let Janelle know beforehand that my father was going to be on premise. I gave her a 24-hour heads up and let her knew. And she knows that it is like
Ma'am, I'm just gonna stop you. Were the locks changed?
the locks, like my father mentioned that there were no access to the premise. And he
I don't
can't,
know what that means. Did he change the locks?
he did, yes, correct. From my understanding.
Why?
But because he couldn't get in the premise, but he did provide Janelle with the key, the new key.
Did he give you a key?
no, what happened was the police came because he showed up unannounced. I came home. He pushed me out the house. The police came and he changed the locks and they made him take the lock off and put the initial lock back on. That's what happened when the police came.
But we never have access to like we're not able to have access to do any repairs in this case. And he did tell the police that he was going to give the keys to you, right, Janelle?
No, they made him the city guy was in a police and they made him put the original lock back on.
All right. Um, so are you requesting a money judgment in this case?
In this case, I would love to just have a, a motion to evict the tenant.
Because you requested a money judgment on this case, and there's going to be a huge problem with that. The other question is, I guess,
Yes, I did we like request a money judgment because I've always been like in contact with Janelle. I always provide a clear payment ledger with her during that time, and all those are forwarded through email.
So, ma'am, did you file this complaint?
My father and I, yes, we filed the complaint.
Okay. And that's David, is your
Correct.
father?
That's right. My father's name is David.
Who owns the property?
I own the property, and
Yeah.
but recently we just filed to in a joint ownership on the property.
Yeah, but yeah, I'm sure recently because he got called out last week. Um, I'm concerned about some of the allegations that are made in here. There was a lease,
Mhm. That lease was
and the lease has expired.
I never,
correct.
I
20,
never had a lease.
no, Janelle, you have a copy.
So
It's
what
back
happened
in
was,
2023. It is in your email.
Now we've hit another major contradiction in the story, the existence of a lease. The landlord says there was a lease agreement and that it expired, but Janelle immediately pushes back and claims she never had a lease at all. Why does that matter? Because in eviction cases, the presence or absence of a lease can completely change the legal framework of the case. If there was a written lease, the court will examine the terms, rent amount, duration, and responsibilities of both parties. But if no lease existed, the tenancy might be considered month to month, which follows different legal rules entirely. Then we hear something even more surprising. The landlord claims Janelle actually has a copy of the lease in her email. So now the court is dealing with conflicting narratives. Either the tenant forgot about the lease, misunderstood the agreement, or one of the parties is simply misrepresenting the situation. And as viewers, this is where things get interesting. Because when both sides present completely different versions of reality, judges often rely heavily on documentation, emails, contracts, inspection reports, which raises a question for you watching right now. Who do you think is telling the truth here?
In 2023 that went through 2024?
Correct. You can refer back to your email, Janelle. This was the
came out
document.
and did an inspection and said that the house
When
was,
did they do the inspection?
they came back in September, they came in December. And what they said was
December of,
2025, like December 9th or 10th. And what they said was, they were like, everyone needs to be on the same lease. What her father told us was that we all have to say that we're related, everyone, because it was a rooming house. And they said it was an illegal rooming house.
oh my God.
This revelation completely changes the scope of the case. Janelle claims the house was being run as a rooming house, meaning multiple unrelated tenants were renting rooms within the same property. But according to the judge, the property was officially zoned as a single-family dwelling. That's a huge legal problem. Many municipalities strictly regulate rooming houses because they require additional safety inspections, permits, and occupancy limits. If a landlord rents out multiple rooms in a property that is only approved for single-family use, that could violate city zoning laws. And listen carefully to what Janelle claims happened. She says the landlord's father allegedly told the tenants to pretend they were related if the city asked questions. If that claim is accurate, that would be extremely serious because it suggests an attempt to bypass zoning regulations. Judge Simpson's reaction, "Are you kidding me?" tells you everything you need to know about how concerning that allegation sounds from the court's perspective. At this point, the eviction case has evolved into something much larger. Potential housing code violations and illegal rental practices.
Are you
Because
kidding me?
it's
So,
not zoned for that. And I put that in,
no, I saw that, but so how many people were renting this place?
there were 6.
No,
Is that right, Miss Jen?
no, there isn't that many people. There's right now three other people living there.
Mm,
Yes, I can. Yes, it is.
But your certificate was for a single family dwelling, right?
Uh, when I had the certificate, I used to live on premise, and it was like as,
Oh, but
but
you
yes,
lived
it's
on the
now it's
premises. Okay,
yes,
so that I
yes.
get.
But
But
then it was, but now because I'm no longer, yes, you're right. We have to be a single family home.
right, because you're not on the premises. I get
Correct.
that.
Yes.
So when did you leave the premises? Jeez.
So this was like around 2020.
Okay.
That's incorrect. I moved in September of 2019. She did not live there. I lived with 5 other people.
Well, I don't, if she says she was residing there, I'm not gonna go back that far. It doesn't really
Yeah, this
matter, because at some point she moves out. When she moves out, that's when the character of the premises change, and it has to be something different once she leaves. So whether she was there or not in 19, it's irrelevant, quite frankly, for what I have here. But
And we've been very generous to Janelle. We've let her stay there due to, I know she had a lot of hardships with like, trying to get financial aid and having some.
ma'am, well, there's one thing in being generous, and there's also another thing in saying you can stay here, but I'm not going to follow the law. That those are
Mm.
very different things, and I'm not saying they're mutually exclusive, but they are very different things.
Mhm. Yes.
And the question is from the court standpoint, is you're terminating her tenancy. Are there other people still residing in the place?
Yes.
I'm open to terminating everyone's tenancy, but yes, there
You can go
is,
ahead and do
they
that.
are, I
I'm
work
trying
with,
to figure out, ma'am, why, if I have a group of people living on the premises and or at some point would have been informed by the city that it's a single family dwelling, why I have one
correct,
case for
and
one tenant?
you are right. We are, currently, we never changed back to a single family dwelling in which, and the lease has
Yeah, but
been,
I get that. My question is why is this defendant here, but the others that are there not?
uh, you, they are, so from, like, yeah, they are allowed on the premise.
They being whom? These other tenants?
These are the tenants.
What do you mean they're allowed on the premise?
They are, like, we have permission for them to live there.
From whom?
From me.
No. Let me try this again. A house is supposed to be a single family dwelling.
Yes, Your
The
Honor.
individuals, as I'm to understand it, are not a single family. You have basically rooms or that are being rented.
Yes, Your Honor.
You have no certificate of compliance.
Not for this year.
Right. And then for whatever the reason, Ms. Smith is brought before the court for a termination of her lease or a termination of her tenancy.
Yes, correct.
And I'm trying to figure out why her and not the others.
The others have consistently, paying me, we have a rent arrangement with the other tenant, and they have been paying.
Okay, so maybe you really need to get an attorney
Mhm.
because under the Ipsy City ordinance as well as state law, if you don't have a certificate of compliance, you can't charge rent.
And here it is, the legal turning point of the entire hearing. Judge Simpson lays out the law very clearly. If the property doesn't have a valid certificate of compliance, the landlord cannot legally collect rent. That means the entire argument about unpaid rent, the very basis of the eviction case, may not hold up in court. Think about how dramatic that shift is. The landlord initially came into this hearing claiming the tenant owed 2 years of rent and utilities. But if the property was never properly certified as a rental unit, the court may determine that the tenant had no legal obligation to pay rent in the first place. This is why housing compliance rules are taken so seriously. They exist to protect tenants from unsafe or illegal housing arrangements. And when landlords fail to meet those requirements, courts often side with tenants. Judge Simpson even warns the landlord that they could be in a whole lot of trouble, particularly because of the lock-changing incident and the eviction attempt without proper certification. At this point, the case has clearly shifted from a simple eviction request to a potential investigation into the legality of the entire rental situation.
So if you're kicking her out because she won't pay rent, you can't do that under the Ipsy City ordinance because she doesn't have to pay rent because you don't have a certificate of compliance.
I understand, and we're working towards the compliance aspect and trying to get
Okay,
this.
ma'am, I'm gonna let you know this. Here's what I'm gonna do. Because everybody's saying these things and I understand you say you understand, but I don't think you do understand. You guys could be in a whole lot of trouble, especially for the changing of the locks and the moving of her items from a place that she has. Could be in a lot of trouble because you're renting but evicting her and you don't have a certificate of occupancy. And the reason that you're evicting her in great part is because she's not paying her rent, but she's under no obligation if you don't have a certificate of compliance. And so I'm going to set this for a final settlement conference. Give me a date.
February 10th or
I'll set it. No, that's fine. February 10th, 2026, 9 a.m. That is an in-person proceeding. There will be no appearances via Zoom. Everybody's going to have to be here. They're going to look me in the eyes and tell me what happened.
All right, thank
Because
you.
I'm not, there's something's real wrong here. All right, thank you.
Thank you.
Thank you, Your Honor.
And that's where Judge Simpson brings this hearing to a temporary pause. Instead of issuing an immediate ruling, the judge schedules what's called a final settlement conference. This gives both sides time to gather evidence, clarify the facts, and potentially resolve the dispute before the court makes a final decision. But listen closely to the judge's closing remark. Something's real wrong here. That statement speaks volumes. By this point, the court has heard allegations involving an unregistered rental property, possible zoning violations, a disputed lease agreement, claims of illegal lock changes, and accusations that tenants were asked to misrepresent their living arrangements. Those are serious concerns that go far beyond a simple eviction case. Now, the next court date, February 10th, and will likely determine whether this situation results in eviction, penalties for the landlord, or even further legal consequences tied to housing compliance. Cases like this are powerful reminders of how complex landlord-tenant law can become when safety regulations, zoning rules, and tenant rights all collide. And now we want to hear from you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.